Basic Your Lordship indulgence for mentioning one unlisted item, my Lord, which is CRP number 22 of 2024. As per the last court order, it was to be listed today, my Lord. But mistakenly, it does not come up in the cause list, while the analogous matters were listed for hearing from item number 2.
It is not supposed mention is to be for unlisted. Is it not to be made before the senior bench? You have to mention before the senior bench.
No, my Lord, analogous matters are listed before this honorable bench.
Which matter?
Part 2 from item number 2 to 16, my Lord.
These are similar matters.
Similar matters. And as per the last court order, it is to be listed today, my Lord. If Your Lordship...
okay, you are for one of the
respondents, my Lord, in CRP number 22.
All right, call for it then. If it's there.
Oblige, Your Lordship.
My Lord, I have a mention for unlisting, my Lord, the matter for today. My Lord, I am from Gauhati. My Lord, the reason is that, my Lord, in a very erroneous manner, decree was passed, and we have been directed to pay the amount on 20th this my Lord, August. If suppose that amount would be paid, my Lord, nothing would be survived in my this regular 1st April. Therefore, my Lord,
No,
some
but
urgency-
why before this bench?
My Lord, because this matter is taken up by this court number 2, my Lord.
It's a pending matter.
No, newly listed, newly filed. We have filed it on last week. Now urgency is there to take up this matter today, my Lord. We have a prayer for stay, my Lord, for execution case.
No, that is my question. Why before this bench?
The reason is that, my Lord, the civil matter, my Lord, the appeal and others revision petition are being taken up by this honorable court. my Lord.
Is there any such notification?
No, my Lord, but I have been suggested to mention before Your Lordship. That's right.
No, we don't know who suggested. Is that the position, courtmaster?
Yes, my Lord, if anything, my Lord.
Even if it is to be listed before this bench, that will be done by the senior bench. You have to mention it there, then it is for the registry to assign it to any court as per subject. Yes.
Must.
If I may also seek Your Lordship's indulgence. My Lord,
Yes.
this is regarding item number 34, my Lord.
Part 2.
Part 2, item number 34, my Lord. My Lord, though I have not taken the consent of the other side, if I may be allowed, my Lord, to have the hearing of this item on Thursday, my Lord, I'll also inform the other side. And if they are not ready, my Lord, then we can adjourn it for another time. But, my Lord, for the time being, if it can also be considered on Thursday.
A criminal appeal.
It's a criminal appeal, my Lord.
So what is the urgency? It's a 25 matter.
No urgency as such, my Lord, since it has come up.
Now we'll see, let it come.
Certainly, my Lord, certainly.
Yes.
If I make a mention of item 22 of part 2. The I'm appearing on behalf of Mr. Benjamin Lachamwan, counsel for respondent number 1 to 6, and he's not available for this week. So if the matter may kindly be taken up next week.
Okay, if it's called up, you make the mention. No need for mentioning unless you want an adjournment beyond the period of this list.
I seek Your Lordship indulgence in mentioning supplementary list, item number 14. I have been requested by the conducting counsel, Mr. Azad Ahmed. He's having some personality difficulties. I have already spoken to the other side, my Lord. If the matter may be reposted again after a week.
When?
31st?
All right. 31st.
Yes.
This is bail matter.
Yes, my Lord.
So long, why?
He's having some personal difficulties.
But we are required to dispose of bail matters within 2 weeks. All right. On the prayer of learned counsel for the petitioner, list this matter again on 31st. Yes.
Obliged.
Lordship, I seek indulgence in mentioning part 2, item number 31, with the mutual consent of both the parties. And this matter kindly be listed after 2 weeks.
31. All right, after 2 weeks. Give a date. Just say in the next course list, commencing from. Yes.
Prohibition item number 1.
Lordship, in this matter, as per the last court order, notice has been completed upon all the respondents, and the appeal has not been admitted, my lord. In the meantime, the third court record may be, scanned copy of third court may be called for, my lord.
Lord heard learned counsel for the
Yes, so this appellant.
appellant and learned counsel for the respondent number 1. None appears for
2 and 3.
to respondents 2 and 3. All the service is complete. Hence call for the PCR list again on date after 2 weeks. It is already admitted.
Not yet as per the order.
The appeal is admitted for hearing. Call for the PCR list again on.
3 weeks, ma'am.
Give me a mention.
Item number 2. Lordship, I appear on behalf of my senior CGC for respondent 2, and we will not be filing affidavit.
That I am appearing for the petitioner.
Who is for petitioner?
I am appearing for the petitioner.
Okay. And some objection, affidavit in opposition has been filed by respondent number 1, I think. Yes.
That's correct.
Who is appearing for 1?
Your Lordship, I'm here on behalf of Mr. Pasha, the petitioner. Is supposed to be online.
Yes, he is online.
Yeah, respondent. So supposed to be on VC. So technical problem is there. So he cannot log in yet. Can I seek for passover or time for the time being, sir?
Yes, can you wait for some time?
Millets, I can.
All right.
Just for your lordship's information, Millets, respondent number 3 and 4, that is the banks, are also supposed to file their responses. We have not received any as yet. So,
Lordship,
Uh,
let to the Lordship. I am appearing for respondent number 3, Axis Bank Limited, Lordship.
okay.
So
You are
I have-
filing any response?
Lordship, not yet.
And
have
do you
not
intend to or do you need to file any response? You are a bystander.
Yes, Lordship. But the Lordship, one thing is that the petitioner, while filing the writ petition, he intentionally hid out one document. He only submitted the document issued by the ED in regard
Okay, we'll
to-
see that once the council
Yes, Lord.
is there. But
may it please your lordship,
oh, you are there.
Yes, my lord. I'm sorry, my lord. I was not able to connect, my lord, at that point of time. My lord, from all the matters from my lord, item number 2 to 5, my lord, I am appearing on behalf of my lord ED as a special PP in this matter, my lord.
Yes.
Yes, my lord, I am not able to get, my lord, whether, my lord, this matter is item number 3 or item number 2, my lord, because item
I
number 2
think two
also
was called
exists.
up.
Yes, my lord. My lord, yes, item number 2, my lord, may kindly peruse the last order, my lord.
Yes. What about the last order?
Yes, my lord. In the last order, my lord, we have filed, my lord, the affidavit in oppositions, my lord, in respect to the, my lord, writ petition, and also, my lord, in this regard, my lord, one, my lord, authority of the Honorable Supreme Court, that is also submitted, my lord. That is also reflected in the, my lord, order, my lord.
Yes. Yes, that is on record, your affidavit in opposition, filed by one assistant director.
And, my lord, Honorable Court at that point of yes, my lord. Now, my lord, yes, yes, my lord, my lord. Writ petition that is filed, my lord, assailing the freezing order, my lord. Now,
Yes.
my lord, before going to the facts of the case, my lord, we are coming to the, my lord, maintainability of this writ petition. Whether, my lord, this writ petition is maintainable, my lord. Because, my lord, when, my lord, there is a
If I may cut
statutory
short the
provisions, my lord,
That we
which is
will
under,
go.
my lord,
Even if it is
PMLA
on the
Act, my
question
lord.
of
Now, my
maintainability,
lord,
we are required to hear the petitioner first. So, I thought there was some preliminary kind of
yes, my lord,
matters to be
my
taken
lord.
care of. So we were listening to you. No. Yes, petitioner.
Please, my lords. My lords, two factors that your lordships are required to consider. In this case, my lords, my gravamen revolves around two banks. One is State Bank of India and second is the Axis Bank. Now, insofar as State Bank of India is concerned, my lords will just have paper book page 46. That's the order of ED. That's the freezing order. 8 June 2026.
Yes.
I'm just giving a backdrop to Melod's. Melod may not actually be required to go through the documents. So 8 June 2026 is when ED passes a freezing order against me under section 17A. If your lordship will recall the first order, that is admission order in this so far as this writ petition is concerned, I had made two preliminary pointers. One was in relation to 17.1, which said that the power insofar as freezing is concerned cannot be delegated. The second objection was insofar as the order itself is being passed contrary to the provisions of law. Now, having said that, my lord, second gravamen pertain to Axis Bank, where at least insofar as my instructions are, we had only received one letter of 10 June, which specifically by reference to a ED order froze my accounts. Now, Millets will just appreciate one thing in the affidavit of opposition that has been served upon me at paragraph number 13. Millets, the OA details, and that's preliminary objection that my friend is going to raise. He says that under the scheme of section 17, I am supposed to approach the PMLA adjudicating authority once a complaint is filed before the authority. My gravamen today is no such complaint has been filed. And therefore, my lords, the entire process stands vitiated. I can only make or approach a forum once ED makes a complaint. Before that, I cannot make a complaint, or I can't even make a representation to the authority. Now, insofar as paragraph number 16 is concerned, it is left blank, at least so far as the copy that has been supplied to me. I will request my colleague to screen share it if your lordship wants to see. But para 16 reads in this manner, my lords. I'll just read it for your convenience. It is submitted that a statutory application under section 17.
Para 16 of their objection.
Their objection, my lords. For retention of frozen amounts was filed before adjudicating authority within the prescribed period of 30 days. Within the period prescribed of 30 days from the date of freezing order, that is on, and then, my lords, it's a blank there. Now, perhaps the copy that I have received, unfortunately, may have this blank, but insofar as if my colleague can just show it to my lords. This is the copy that we have received. We have already applied for a certified copy. Perhaps there is something different. If
Here there is a
something
date
different-
inserted by hand 8626 being OA number 120 of 2026.
Well, this is not what has been supplied to us, unfortunately. That's the problem.
My lord, that may be a my lord mistaken in our part, my lord, while my lord serving my lord, because my lord at that point of time that blank was there, and my lord may kindly peruse my lord. That is later on my lord, date my lord 8/6/2026, that is date of freezing, and my lord OA number 120/2026. That is my lord, and it is my lord on record my lord by way of affidavit my lord, the authority
OA
my lord,
number?
rating, my lord submitted my lord.
Well, it's
OA number 120/120 of 2026, my lord, which is still pending before the adjudicating authority, my lord. OA number 120/2026.
So therefore, Malas, if we can receive that certified copy, or my friend can supply me this copy, then I'll be able to address the arguments insofar as this is concerned. In my
Alright.
respective submission.
Since that is your difficulty, you supply him the proper copy, complete copy.
My lord, a scan copy, my lord, immediately may be provided, my lord. My learned, one of my learned friend is, my lord, physically present before your lordship. Today itself, my lord, she will provide the same, my lord.
Yes.
Yes, my lord. And my lord, regarding so far, my lord, that is concerned, my lord. If, my lord, even if, my lord, that is what we stated, that within the statutory period of 30 days, my lord, ED filed a, my lord, that is the OA, my lord, 120/2026. My lord, apart from that also, my lord, what is, my lord, in the, my lord, statute, my lord? The statute says, my lord, if, my lord, allow me, I will go to the, my lord, that is the, my lord.
No, we don't
provided-
want to go through all that now. What we want to know is whether we are going ahead right now, or are we having it some other time after you supply
I will
the copy.
request my lords, once I have the copy, my lords will allow me to peruse it. My lords can have it on 26th or any other date convenient after 24th.
26th. I think 26th is a holiday here.
27th, 28th.
My lord, already, my lord, that is the affidavit, my lord, file. Only, my lord, that two, my lord, one date, and my lord, the OA number was missing, my lord. That may be provided today only, my lord. Late, my lord, a short date may be given, my lord. It is only on the base of a, my lord, only, my lord, the statutory provision. Where, my lord, High Court is a appellate court, my lord. In that case, whether, my lord, under 226 a writ lies or not. That is, my lord, our, my lord, questions,
That's all
my lord.
right. It's his goose which is on the fire, so let him have his time.
My lord, my lord, my lord, my lord, my lord, my lord,
There is no stay order.
my lord, my lord, my lord.
So when do you want? I think 26 is a holiday here, and so is 28th. So you can have it, or no, 27 would be a bit dicey because we have very limited number of cases when that is the last working day. So maybe on first.
Yes, my lord.
First?
That is also not. First would be fine.
First.
Heard learned counsel for the petitioner and learned special. What are you special standing?
My lord, special public prosecutor, my lord.
Special public prosecutor appearing for ED stroke respondent number 1. Mr. So and so appears for respondent number
I'm appearing for respondent number 3, P does lordship.
P does. And that is all.
Lordship, if you're
Okay, Mr. So and so appears for respondent number 4. Will you be filing anything?
Lordship, if your lordship kindly allows me, can it be taken up on 2nd of September instead of 1st?
Does that work for you?
Well, we have no difficulty.
All right. All right.
I will
Second.
file my affidavit, lordship.
Okay. Second is again DB.
Third. On 3rd, then lordship.
Okay. Third. All right.
Very well.
3rd of September. It is submitted on before that, you write. It is submitted on behalf of the petitioner that the affidavit in opposition, copy of the affidavit in opposition filed by respondent number 1 as served upon the petitioner has some missing parts in paragraph 16 thereof. Full stop learned special PP submits that the complete copy of the affidavit, said affidavit in opposition stroke objection shall be served upon the petitioner, learned counsel for the petitioner during the course of the day. Place the matter again on 3rd of September. In the meantime, the respondents number 3 and 4 may also file their counter at least 7 days before the next date. Said date.
Item number 3.
Your Lordship, I have taken steps upon the respondents and the AD card is still awaited.
My lord, in item number 3, 4 and 5, my lord, it is, my lord, that is the respondent, my lord. In this regard, my lord, we are not receiving copy of the writ petition. My lord, that may be provided. My learned friend, my lord, that is physically present, if it is provided to her also, my lord. And on the next date, my lord, we will file our, my lord, affidavit in opposition, my lord.
Already heard learned counsel for the petitioner. Learned special PP for ED submits that copy of the petition has not been furnished to him. Petitioner is directed to furnish extra copies to the respondent number 1 within 3 days. Notice on respondents number 1 and 2 is not yet complete. Await report of service. List the matter again on.
After 2 weeks, my lord.
And this also come on 3rd September. I think it will be easier for you.
My lord, if the interim order may continue, my lord.
Already interim order passed earlier to continue till the next date of listing.
Oblige.
3rd September, my lord.
3rd September. Same date as
Deeply
the
obliged.
other case.
Yes, my lord. Deeply obliged.
Item number 6.
My lord, sir, if common order can be passed in 4 and 5 as well. Item 4 and 5 as well.
4 and 5.
Yes.
It's common order.
Yes, my lord. Oblige.
Yes, ma'am. Obliged, ma'am.
Your Lordship, the order passed by the learned single judge is challenged by the respondent, my lord. The writ
Yes, I
appeal
think
is
lot of
pending.
service remains to be complete.
Yes, my lord. A complete service.
Respondent number 1, AD card awaited.
I am
2
for
and 3
respondent
are
number
represented
2 and 3.
for you are. No, earlier respondents were struck off. New respondents are there. You are for whom?
I am for respondent number 2 and 3.
No, in office note says that in terms of order passed in the IA, names of earlier respondent number 2 and 3, who were represented by MS Zairem Sangkwe, and new respondents have been put in their place, but no wakalatnama has been filed. So you may have been appearing for the earlier ones struck off, or the new ones.
My lord, I have.
Get it, see, you verify.
Yes, my
We'll
lord.
take it after some time.
Okay.
Check it up if you're there.
Item 7.
My lord, in this case, the state respondents have belatedly preferred an appeal against the judgment which they are seeking to implement. So this may be adjourned for 2 weeks, my lord.
It is submitted that the respondents have preferred an appeal against the judgment in respect of which the present contempt petition has been filed, and it is accordingly prayed that the matter be adjourned for 2 weeks. List the matter again on given date.
Item number 8.
What's up?
None appears for the petitioner. An affidavit of dusty service has been filed stating that dusty service was effected upon the sole respondent by serving copy of the petition on 17/7/26, and the signature of the sole respondent has been obtained in the notice along with the signatures of 2 witnesses. Full stop. Having regard to the above, service on the sole respondent is deemed to be complete. Full stop. However, none appears for the sole respondent. Place the matter for admission on so and so given date.
8th of September. Item number 9.
May I please, Your Lordship? My Lord, this is a regular bail application of the petitioners who were arrested on 20/11/2025 in connection with Special Narcotic Police Station case number 37/2025, my Lord, under section 22C/25/29(1) of NDPS Act, my Lord. More than 8 months, my Lord, they are in jail, my Lord. Basic fact of the case, my Lord, page 16.
Who is appearing in this case? Prosecution. Hello.
Here, my Lord, the petitioners were arrested, but they were not furnished, my Lord, all the mandatory notice and information in time, my Lord.
Which one?
My Lord, 40, as per my instruction, my Lord, the notice under 48 is totally not furnished, my Lord. And notice under 47 is not properly, my Lord. Only, and
Where is 47?
47, my Lord, I have not, my Lord, it is not in the record, my Lord, Lordship.
Then we have to see the record.
Yes, my lord, it is not furnished, my lord, in time also, my lord, as per my inspection, my lord. And 48 notice is totally not given.
So that is your ground, incomplete 47 and then
Yes,
nil 48.
Nil 48.
Okay. Yes, prosecution, and you have the record.
Yes, Your Lordship, the scanned copy has reached. It is there.
And in the 47 also, my lord, there is not date, my lord.
Your Lordship, I have put a mark in the grounds of arrest as well as arrest intimation.
So where is the 48 notice? You haven't flag marked it.
48 not furnished, my lord.
Not furnished.
Yes, 48 is not there. But however, Your Lordship, there is intimation, but they named it as 47. But that actually is intimation to their relatives. So the section which they have quote, it's a typographical mistake, and it is written section 47. The same was accepted by their representative, Your Lordship.
And there is no date also, my lord.
I believe that in their signature there is a date.
In arrest intimation, my lord, left hand side, my lord, and right hand side, my lord, there is no date. It is, and in the, my lord, notice under 47 also, my lord, date is not there. And no ground is mentioned, my lord.
So when did you have that copy?
New one.
Of course, I do. This is what I have the next thing.
So 47 appears to be okay. You are intimated grounds of arrest.
But, my lord, there is no date, my lord.
Your Lordship, here
And
it is
it
written
ought
that
to
they
be,
were
my lord,
arrested on 2011-2025.
It is to be submitted, my lord, within 24 hours, my lord.
And that is reflected in the magistrate's order.
Yes.
It was there before the magistrate.
Yes, my lord. But 48, my lord, total missing, my lord. 48 not furnished.
Even the magistrate's order does not mention anything specifically regarding notice under 48. Is it not?
Yes, my lord.
Your Lordship, if I may take you to page 21 of their application. Your Lordship, here the bail application has been applied before the trial court and with the same ground, and the same has already been rejected. And that is the
Page?
page 21. The operative portion is in page 22, paragraph number 4.
In my petition, my lord.
No, not on the same grounds. Grounds are totally different.
Here it is stated that the grounds of arrest and arrest intimation were duly furnished to the accused petitioner and their family members in their own language. In
What are you reading from?
page number 22, para number 4. That is the bail application number 109 of 2026 before the Special Court NDPS Act.
Well, we'd like to know whether learned magistrate saw this from. If he can see it, why can't we see it? Was he seeing some other record?
And Your Lordship, with regard to arrest intimation, it is written that the below noted person who were arrested in connection with the above reference number and arrest intimation was given to his or her relative as mentioned against name and encounter signed by the arrested person. So, Your Lordship, the phone number and the person has been mentioned by the accused himself. And in that regard, Your Lordship, I have one citation passed by the coordinate bench on 27/7/2026, Your Lordship. I'm sorry, Your Lordship, the citation which I have present, that is not the correct citation. Actually, that is also the rejection order, but however, the citation which I would like to rely is bail application number 55 of 2026, passed on 16/7/2026. And in this judgment, it is clearly mentioned regarding section 48 and 47, Your Lordship.
So you are not relying on this?
I will rely on this as well, but the
You
main
say it's not a correct
citation-
judgment.
Yes, the main citation which I would like to rely on section 47 and 48, regarding 48, that the contact number and name.
No, in this case, what the court has held is that as far as 48 is concerned, grounds of arrest have been communicated in writing to the brother of the applicant, which is clearly reflected in the case diary. But you have not been able to reflect anything.
Yes, so the citation which I would like to rely is bail number 55 of 2026, Your Lordship, passed on 16/7/2026 by the coordinate bench.
Yes, what does it say? Get a copy.
Yes, now they are getting the copy, Your Lordship.
On this point, my lord, I have the next one judgment, my lord, page 34.
Yes, we have seen that.
Page 34 in
So rest is all over. You are now only to satisfy us that 48 has been complied with. We have the scanned copy from where there is no such compliance available.
Yeah.
Only thing left is you have some judgment to cite. So get a
Yeah.
copy of that and hand it over to us and we'll decide.
Yes, Your Lordship.
Chamber.
Keep them.
Give a copy to him also. Or at least you note the citation and find out if you have anything to say.
Yes, diploma.
Item number 10.
My Lord, this is also bail application. On the last court date, scanned copy of trial court report has been called by this honorable court, my Lord. And it seems it hasn't reached this court yet, my Lord.
Not received today also.
Not received yet, Your Lord.
Which court is this?
Scholarship District Court, my Lord.
So what is the difficulty? Any internet problem?
Tashitomi.
Rashito.
The original copy is called for, I think. Is it?
My Lord, in this
Office
case, there
note
are
says
six.
TCR, not scan copy. Huh? Where is the order? First order. Scan copy was called for.
Last court date is 11/8/2026, my Lord.
Which court in Kolasib?
Fast track court, Kolasib, my Lord.
What fast track court? Name of the court is fast track court.
Yes, fast track court, Kolasib District, Kolasib, my Lord.
This is NDPS.
Yes, my Lord. And the grounds taken by me is the same, my Lord, 47 and 48 violation, my Lord.
Should be special judge, I think.
Yes,
Kolasib. Huh? Yep. What is it? Additional district judge or special judge? Something it should be there. Just. Is it judge?
fast track court. My Lord, it's just written fast track court, Kolasib, my Lord. My Lord, in this case, there are 6 accused, and out of 6, 2 have already been granted by this honorable court on the same ground. Violation of 47 and 48. my Lord.
Where is that?
First case is, my Lord, it's in Annexure 7 of my bail application. Accused number 2, my Lord. And here I represented the accused, my Lord. It's in page number 37 of my bail application, my Lord. The relevant portion is in paragraph 13 of the order, my Lord. It's page 41. May I read the.
So in this case, no notice was issued, the order you were citing.
Yes, my lord.
In your-
48 notice was not issued to the
No,
relative.
47 also, because this says that learned additional PP admits that there was no notice
In-
under section
in this-
47.
In this bail order, my lord, in this case, in the case number 2, no notice was issued, my lord. Even 47 also, my lord. But here in the present case, notice under 47 has been issued to us, but not under 48, my lord. And in another bail order, my lord, in Annexure 8, another co-accused has been granted on the same ground, my lord. The relevant portion of the bail order is in 47 of the my bail application, my lord.
No,
Starting
you
from
see, the problem is in, it has to be seen individually. It may not have been served to him, but whether it was
Though-
served to you or not, we don't
Yes,
know.
yes, my lord. Though my case is not exactly same with the bail order granted to accused number 2, my lord, but to accused number.
Okay, let us have it on
16.
Friday. We'll direct the court to submit. Heard learned counsel for the petitioner, learned additional PP, despite the order of this court and reminders from the, despite the orders of this court, the scanned copy of the TCR along with CD has not been furnished. On perusal of the office note, it appears that the same was called for only on 12/8/2026.
It's 11/8, my lord.
We don't know, registry's order reflects. So today is how many? 5 days? 18, 6 days. List the matter again on, okay, we'll have it on Friday.
Your Lordship, if possible on Monday, because Friday I have some personal difficulties.
Again on Monday, okay. The learned judge FTC court Kolasib, FTC Kolasib is directed to ensure that the scanned copy of the TCR along with CD is transmitted to this court before the next date fixed. List again on Monday. Communicate a copy of this order to the judge FTC court Kolasib.
Obliged.
Obliged, my lord.
Item number 11.
Yes.
Yes, Lordship.
You have to take fresh steps not yet taken on respondent number 1.
Respondent number 1.
Lordship, we have received instruction from respondent number 1. And
You have?
Yes, Lordship. Respondent number 1.
What about 2? Not yet returned.
Lordship, there is an gas appeal.
Huh?
There is an gas case. There is an meg appeal 4 of 26. Even in that case, I was given permission to make a substitute service by way of newspaper publication. So kindly allow me to make that newspaper publication.
Who are 2 and 3? Driver?
Driver and owner. of the accident vehicle.
Insurance coverage is there.
Yes, coverage is there, but there is some grounds.
Are they within the state or outside?
Oh, outside the state. They are the residents of Karimganj, Assam, and Digirpar, Kachar district, Assam.
So the liability is on insurance company. You are challenging on what, quantum?
No, not only the quantum, but we challenge that there is no proof that the accident occurred due to sole responsibility the part of, because the no charges was produced and
Oh, this is by the insurance company.
no charge sheet was submitted, nor any final investigation report was submitted, exhibit. And regarding the monthly wages, we have denied the monthly wages of the deceased. And the driver of the accident vehicle did not possess a valid driving license to drive the accident vehicle at the time of the accident.
So you have been permitted to recover from the driver.
Yes, exactly, Rosip. But in our opinion, there is no sufficient proof of the cause of accident and the income of the deceased. Because as per the tribunal, the deceased was only 15 years old at the time of his death, was earning around 15,000 per month as a barber. So that cannot be accepted.
So you were made liable to satisfy the award and thereafter recover it from the driver. Finding of the tribunal was the driver was at fault, and since he had no license, you can recover it from him.
From the owner or the driver of the accident vehicle. That is a vague even.
So your challenge here is what? You say it's not against quantum or anything, it's against your liability to pay.
Yes, liability. Lordship, in this case, neither any charge sheet nor any final investigation report was exhibited or produced by the investigating officer. So the finding on negligence, which is the foundational factor for a claim.
So it is entirely on merits, not on who is to pay or who is not to pay.
No.
That is your stand, that he is not entitled to any award.
Yes, he's not entitled.
Because there was no such
because the
negligence
claim
or
was filed
whatever.
under 166 of MB Act. So
Yes.
proof of negligence is a must.
Yes. No, I am trying to find out whether owner and driver is really necessary. That is why. Respondent number 3 has come back as insufficient address. You have taken only once, is it not?
Yes.
Straight away, we should not go for paper publication. You make another attempt. It heard learned counsel for the petition appellant insurance company. Mr. So-and-so has entered appearance for the respondent number 1. Who is respondent 1?
One is the claimant's man.
Huh?
Claimant.
Claimant.
Slash.
Okay. It appears as per office note dated 14/8/26 that as per postal consignment tracking report in respect of respondent number 2, notice has been returned back to the sender upon failure to deliver the same. But notice is yet to be received back by the registry. Full stop. Notice sent to respondent number 3 has been returned unserved on 13/7/26 with postal remark insufficient address returned to sender. Full stop. It appears that during the trial, the respondent number 3 had appeared and filed.
No, Lordship. He did not contest the case in the trial court.
Not the driver. Owner had contested. Owner is
Yes,
3,
owner-
isn't he?
owner is 2. Lordship.
Owner is 2.
Yes.
Owner is 2. Number 2 had contested the case by filing written statement. This trial was upon receipt of notice. Hence, the reason for non-delivery is not clear. Respondent number 3, driver, was he served or did he simply not appear?
The only thing reflected as per the judgment, which is at page number.
That means he was served. If it was, there is an order that it will proceed ex parte against him. The case proceeded ex parte against the OP number 2, present respondent number 3, which also indicates that notice was served upon him. Full stop. Hence, petitioner to take fresh steps upon respondents number 2 and 3. Raise the matter again on 4 weeks.
24th of September. Passover item number 6.
My Lord, as per order dated 2/12/2025, in IA number 221 of 2025, 2 respondents were implicated, my Lord, but they have not yet been represented till date. So, fresh step may be taken against those 2 respondents, my Lord. Respondent number 2.
Now you are appearing for any respondent?
For respondent number, now, I file my power for respondent number 2, 3, and 4. However, respondent number 2 and 3 already struck off. I'm still representing respondent number 4.
Okay.
I already filed affidavit for respondent number
So new respondents number 2 and 3 are not yet served.
Not yet served, yes, my lord.
All right, heard learned counsel for the petitioner. Miss so-and-so appears for respondents number
4.
Respondent number 4. Who is one?
Ajit Majumdar. He already filed affidavit, so first reply.
I think respondent 1 also is deleted.
Yes, deleted. In place of respondent number 2 and 3. No me. Another 2 respondent has been added in that place.
Any amended?
Amended cost title was submitted on 8/5/2026, my Lord.
Incorporated in the petition now.
We filed the amended cost title on 8/5/2026, but my Lord, since there is no specific order for taking of fresh steps against the newly impleted respondents, so no steps have not yet been taken till date.
Original 4 was Avijit Majumdar. Now he has been transferred and now one Om Prakash Tiwari is there. He is 5.
Yes.
So this is the amended cause title. Is it not? This is 4th of December 24.
Second December 2025.
And that is what I am unable to find. Is there? All right.
So.
All right. Heard learned counsel for the petitioner. As per office note dated 14/8/2026, there are 5 respondents in the matter. Full stop. It also appears from office note dated 2/12/25 that as per order dated 02/12/25 passed in IAC 221/2025, the name of the original respondents number 2 and 3 were struck off, and the name of new respondents number 2 and 3, namely K. Shatish Nambudiri Pad and Ramesh Singh Chauhan, have been inserted as respondents number 2 and 3 respectively. Furthermore, respondent number 5 was implemented by order dated 23/6/2025 passed in IAC 93/25, and no notice is yet to be issued to the said respondent. Accordingly, issue notice to the newly implemented respondents number 2, 3, and 5. Respondent number 4 is represented by Miss So and so. You have filed one affidavit, I think.
Yes, I already filed for respondent number 4
And affidavit
on 7/5/2025.
behalf of respondent number 4 has already been submitted. Full stop. List petitioner to take steps by speed post AD within 3 days. List again on. Give date. 4 weeks.
Item number 12.
Your Lordship, this matter is listed for motion, and in fact, the issue which I have raised by way of this writ petition is exactly similar with item number 3 to 5 of today's list, my lord. What happened is that, my lord,
3 to 5.
yes, it's I have put to challenge the show cause notice issued to me by the adjudicating authority under the Prevention of Money Laundering Act, mainly on the ground that the adjudicating authority, who is now functioning as a sole member, my lord, as per the Act, my lord, the adjudicating authority should consist of the chairperson and 2 other members. But now the acting chairperson, who is the sole member, is conducting all the proceedings under the PMLA. So I put to challenge the show cause notice issued to me, my lord. So in those other 3 writ petitions, my lord, the show cause notice has been stayed, my lord. So I'm praying for a similar
Let us see
direction.
the order in that 3, 4, 5.
My lord.
In any one. We sent it back. So we passed the same order.
My lord, my lord. I'm obliged, my lord.
You give, show me one of that motion order in this.
Obliged, my lord.
Item 13.
Your Lordship, I believe that pleading is complete and let this matter be fixed for hearing.
My lord, there is some urgency in this matter, so if this may be taken up as admission hearing in the coming week.
No, Lord. So you are not filing any reply.
Won't be fine.
All right, heard learned counsel for
And
the
Your Lordship, there is a similar matter pending before this court. And Your Lordship, if that matters may be taken together on the same date, because it seems that that is a similar matters.
My lord, those were handled by other counsel. The issue are not similar. The similarity is that they have been terminated from the service, but the manner in which they were appointed are not similar. The grounds taken by the petitioners were not similar.
So Your Lordship, if that matter may be taken on the same day.
They may not be exactly similar, but there will
Yes.
be
Some similarities is
some
there.
similarities there.
Yes.
With regard to dates and all.
Oh, akan ano kan?
When are those listed?
I don't know exactly when it will be listed, Your Lordship. I will inquire and inform the court master.
All right, heard learned counsel for the petitioner and learned GA for the respondents. Affidavit in opposition has already been filed. Learned counsel for the petitioner submits that no affidavit in reply will be filed and prays for listing the matter for admission as there is some urgency. Learned GA submits that similar matters are also pending. There are other similar matters pending. Hence, when can you give the numbers?
I will give the number today itself.
My lord, if Your Lordship can wait for a moment. They have referred one writ petition in their affidavit, but I have inquired this and
in withdraw
my lord, in their affidavit they have referred to one writ petition number 83 of 2025, and that has been withdrawn on 2nd of March.
All right, then forget this last line. Place the matter again on. Yes, when? Give a date.
If Your Lordship can accommodate on next week, Monday or Tuesday.
Your Lordship, if possible on Thursday, because at the present we are having some family problem.
This Thursday?
No, next week. Due to some sickness, we are facing some family problems. So
Next Thursday will be the last working day. So there
then
will be a...
if
we can give an attempt on 25th at least.
25th, yes.
That is
Yes.
Tuesday.
25th we can.
Tuesday.
25th.
Much obliged.
Anyone for hearing?
My lord, if I may, my lord, I think item number 1, my lord.
Item 1.
My lord, item 1 for part 2 items, my lord,
Oh.
they have been listed for hearing. Item 1 to item numbers. My lord, item
Yes,
number
what was your prayer? You had made some
15.
prayer.
These are analogous matters, my lord. No, my lord, I had prayed for another item. The item I had prayed for was item number 34.
Now, in respect of 1, what is you are there?
Now, yes, my lord. Item number 1 to item number 14 are analogous matters, my lord. Now, my lord, I appear in item number 1, 3, 4, and 5. Now, my lord, there is one thing that I want to pray, my lord. This is because though these matters have been filed under Article 227, my lord, the records have not been called, my lord. The lower court's records have not been called. Now, if your lordship will see one of the items in which I am appearing, my lord, this is in item number 4. In item number 4, in the judgment and order itself, my lord, it is reflected at paragraph number 8 that the applicants had produced 3 witnesses and the opposite party respondents 1 witnesses. Now they have, my lord, their depositions are not present in the records, my lord. They have not annexed their depositions. Now, my lord, this is just one of the incidents where the lower cost records would be required, my lord. So, my humble prayer at this stage is before we have this full-fledged hearing.
You are appearing
lord,
for
should the lower cost
one of the respondents.
I am appearing for all the yes, I am appearing for the respondent, for the private respondents, my lord, in item number 4.
Right. Who is appearing for Power Grid?
My lord, I appear for power. My lord, this particular matter, there are 3 foundational grounds on which we are challenging the judgments. Now, my friend here would say these are analogous matters. I'll beg to differ, because one of the primary grounds which we'll have to go and explore is the ground of limitation. Now, my lord will appreciate the fact that each of the 15 cases, the issue of limitation will have to be decided independently, my lord, because none of the cause of actions, I presume, would have originated at once. Now, my lord, in several of the petitions, what the court below did, that they have taken a bunch of applicants and decided the matter. Now, when the issue of limitation has to be decided individually as per every individual who presumes or shows himself to be affected from the date when the cause accrues. Now, my lord, that being said is a separate aspect. The other 2 grounds on which we are challenging all the judgments is that A, my lord, the judgment has wrongly interpreted the guidelines given by the union government, trying to give them a retrospective effect when they did not have. It is specific. The second aspect is that in some of the judgments, the court has gone ahead to implement the LARA, my lord, the right to fair compensation of land acquisition 2013 Act. When the act in itself says that I am not applicable to the Electricity Act, the act under which I am constituted and I am governed. Now, the third aspect is, my lord, that I have been given the powers of a telegraph authority by a notification of the Government of India backed by a legislation. That we will find it in section 164 of the Electricity Act. Now, that being said, my lord, I have been given the powers of a telegraph authority, and under part 3, I exercise those powers. Now, under part 3 is also a mechanism to see the compensation which I have fixated. I'm giving a bird's eye view, my lord, of the matter at hand. The honorable court below, the court of the district judge, who is the only authority empowered by law to decide on any matter where the sufficiency of compensation is not adequate or is claimed not to be adequate, has delegated his power upon the district authority. So these are the primary grounds on which we are challenging the judgment, my lord, because these judgments will have a cascading effect in future. We are an active agency. My lord, in the implementation of infrastructure projects, primarily dealing with establishment, maintaining and extending the transmission systems throughout the country, and at present with regards to these litigations, my lord, in the state of Missouri. So, if my friend over there would like the lower court records to be come on board, my lord, I will file an affidavit, and on that affidavit we will bring out all the records of the cases and we'll place it before the court, and then we can continue with the hearing.
All right.
But I think, my lord, what will be better, if I may, my lord, what will be better is, my lord, if the lower courts records are called, and if paper books are made, my lord, then it will be more comprehensive, and it will be more fair also, my lord. The registry can prepare the paper book. I think that will be much better, my lord.
My lord.
So you are not willing to accept what he proposes to file?
My lord, because now that they have already filed their petitions, and their petitions, my lord, does not have all the records. Now it is doubtful, my lord, that the affidavits also will have all the records. So I think the best option, my lord, the fairest option would be if the lower cost records are called and if paper books are made, my lord.
Those are disposed of matters, aren't they?
They are disposed of in the lower
We
court.
have no difficulty in calling for the records as sought for by your friend here. And we also won't stop you from filing an affidavit if you like.
My lord, and be as it may, my lord, the jurisdiction under which we have come under 227, the primary reason again is that there is no mechanism of an appeal under the Telegraph Act against the judgment of a district judge, my lord. Thus, the only route open to us is under 227. It's established procedure. Now, my lord, also since we are challenging the government guidelines, the interpretation of the law, what we are saying is that the learned court below has gone beyond its jurisdiction. Now, why it has gone beyond its jurisdiction, my lord? If my lord can only see section 16.5 of the Act, Telegraph Act, it's may I read it? I have a copy. I can just. I'll stop on this, just giving a brief of what the matter is, and we can call for the records, and I will also file an affidavit with regards to the issue of limitation. My lord, 16.3 says, if any dispute arises concerning the sufficiency of the compensation to be paid under section 10 clause D, that is where I exercise the powers of a telegraph authority, my lord. It shall, on application for the purpose by either of the disputing parties to the district judge within whose jurisdiction the property is situated, be determined by him. Now, my lord, to understand the definition of a district judge, we will have to travel down to the General Clauses Act, subclause 17 of clause 2, my lord, which defines a district judge as a constitution and extension of a civil court, my lord. Now, why I say this? Because this will attract the limitation act, my lord, under Article 137. My lord, it continues. Every determination of a dispute by a district judge under subsection 3 or subsection 4 shall be final. So, my lord, once it has attained finality, there is no scope of an appeal. The only route open to me is by way of Article 227. Now, I know my tunnel of argument and the room where I can spread my case and the grounds are limited, my lord. And thus, the grounds on which we have come, it is not my case that the evidence as has been led over there has not been appreciated correctly. But yes, it is my case that the issue of limitation has not been framed. It is not my case that they are entitled to compensation or not. But yes, it is my case that is the district judge the only authority who can decide upon the compensation, or can the district judge delegate that authority? And the answer is in the negative, my lord, they cannot delegate the authority. It is also not my case whether I acquire land. But my case is that the Land Acquisition Act of 2013 is not applicable to me. So, my lord, this is the basic overview in which we would be arguing the matter. The records may be called for, my lord, I may be allowed to file an affidavit to make the process swift and faster. And also, my lord, I would file another additional affidavit for regards to bringing the components of limitation on board, so that the matter.
It is better you file a comprehensive affidavit. Already will call for the records, but for us it becomes very cumbersome to go through the records at different places, and so it's in a comprehensive matter if an affidavit is available. If there is something to dispute in that, it's open for you.
My lord, like I said, what has been deposed is not my case. My case is how it should have been appreciated and who could have decided upon the issue collectively.
Yes, all right. Heard Mr. Yuva.
And Khera, my lord.
Here are learned counsel for the petitioner and Mr.
Joseph Rensley, my lord.
for the private respondents. We'll just say private respondents. Okay, in all these
My
matters.
lord, private.
No, my lord,
My
there
lord-
are different councils.
My lord, every matter may have a separate order because the issues are not absolutely the same. Somewhere interpretation has gone on
Yes,
either
it's all
side of
right.
the
It will have a separate order, but as far as possible, we are making it applicable to all the matters.
My lord, at this
Mr.
stage,
So and so, okay, you give the names of the different private councils. Okay.
at this stage,
Petitioner will be common to all the cases, petitioner counsel.
Certainly.
with your lordship permission, at this stage, if your lordship may allow me to make a preliminary objection to the prayer made by my learned friend. My learned friend has stated that there is no appeal provision for filing an appeal against the impugned judgment. Now there is a Mizoram Civil Courts Act, wherein they have the right to file an appeal under that section 17.
Have
Maybe
you filed any opposition?
They have not filed an appeal. We have filed an objection regarding to that.
Okay,
Now,
we'll hear that together.
my learned friend has...
We can't hear one part of the argument now,
No,
one part later. So
No, my lord, he has sought for time to file additional affidavit touching upon the question of facts, even though he had sought to file this civil revision petition on the question of jurisdiction.
Okay, you have filed your objection. If he chooses not to address that, that is at his own peril.
Yes, my lord.
So why should you be worried about that?
Now, I'm worried about that he will be given the time to file this additional affidavit because in the last court date for 5 consecutive times, he has prayed time for filing affidavit in reply. And we might have lost the trust of our client also due to his prayer.
No, I think today's prayer is in response to the objection raised by learned counsel for one of the private
Yes, my lord.
respondents regarding depositions not being
My
available.
lord, my lord.
So, anyway, we are where we are.
Yes.
And learned counsel so and so for the private respondents, give the names separately. State is also a respondent?
DC.
Yes.
In
Okay.
fact, state is the only actual effective respondent for my purpose because we have challenged their authority to take delegation.
So and so for the state of Mizoram.
It would be the DC Deputy
Deputy
Commissioner.
Deputy.
Deputy Commissioner.
Okay. Represented by Deputy Commissioner. State of
No, the party is Deputy Commissioner, my lord.
Huh?
The respondent is Deputy Commissioner. Respondent
Deputy
number 2.
Commissioner.
Yes, my lord.
Okay.
In
For
all
the
of
Deputy
them,
Commissioner.
The last respondent is the deputy commissioner. On top of the private respondent.
It appears that the records have not been called for yet. And learned counsel for the petitioner submits that he might be permitted to file an additional affidavit incorporating the contents of the records in a comprehensive manner. Affidavit in that objection is filed only in your case,
Item number 2.
only in item
Yes,
number
my lord.
2. Okay.
And item number 6 is my case also, my lord.
Okay. So not necessary to mention objection today,
No.
because that will make it all. If it's on record, it's on record anyway.
In all the cases, private respondent have filed a written objection. In all these cases.
All the cases?
Yes, my lord.
All right.
He has filed a rejoinder also, the petition.
In all the cases, yes.
In not all the
Objection
cases.
has affidavit in opposition has been filed in stroke objection has been filed by on behalf of the private respondents, to which reply has also been filed by the petitioner. Para having regard to the above, call for the records. In the meantime, additional affidavit may also be filed by the petitioner. List the matters again on. Yes, give.
My lord, only in respect of item number 2, that is CRP 12 of 2024, we have not filed a reply. We were awaiting certain information from the department because the matter is very old. So I may be allowed to file an affidavit, a rejoinder affidavit there.
Okay,
In
item 2, you write no reply is yet been filed on behalf of the petitioner. Learned counsel submits that he will be filing the reply shortly.
My lord, in the event they
Item 2.
fail to file in that next court date, courts may be imposed. Because they have taken 5 consecutive times to file.
Observation is not necessary, my lord. If I don't file, it will be, I am ready for an hearing. If it is not filed, we'll go ahead with the hearing. Require that much time to obtain from the.
Yes. 15th of September.
Obliged, my lord.
15 September.
This is 1 to
1
to
to
15.
1 to 15.
My lord, there is an interim protection that we are enjoying that may continue till then.
interim order, if any, to continue till the next date of listing.
We request that my learned friend would be here physically on that day, that fixed date.
Okay, any other matters?
Obliged.
Your Lordship, may I seek indulgence in mentioning part 2, item number 17. Although this is fixed for today's hearing, my senior Miss Mariel Kiangte has some personal difficulties and I have taken...
I think it's already been adjourned, 17, till 3rd of September.
Your Lordship.
Yes. Is anybody else ready for hearing? No.